Good evening, everybody. Hi. My name is Ben Barrows. I'm the Dean of the College of Law. I'd like to welcome you here tonight. It's a wonderful turnout. I think you're going to really enjoy this presentation. This is the David S. Stone Law Lecture, which is a collaboration between the College of Law and the Jewish Federation of Greater Toledo. We're very grateful to the Federation for involving us in this endeavor. It's a really wonderful event. I would like to introduce Connie Zemmelman. Judge Zemmelman will be introducing our speaker. She is a very distinguished alumna of this fine College of Law. She also taught here for a number of years, and I'm very grateful for her to join us tonight. So, without further ado, Judge Zemmelman, thank you.
Okay. Well, I'm honored to welcome you to the Toledo Jewish Community Foundation's David S. Stone Law Program featuring distinguished attorney Raymond Dowd. The David S. Stone Law Lecture was established in 2001 through the generosity of the David S. Stone Foundation based in Washington, D.C. The late David Stone was born in Toledo and was a member of Congregation B'nai Israel. He and his brother Archie were involved in numerous real estate development projects in this area. After World War II, David Stone and two real estate development projects, after World War II, David Stone and two real estate developers from the Washington, D.C. area developed Kenwood Gardens and Larchmont Gardens, both Government 608 housing projects. David subsequently moved to D.C., but continued his awareness of Toledo's needs through his relationship with Judge David Katz. Is he here? Where's Judge Katz? He's in Cleveland. Okay. David Stone passed away at a young age, leaving significant funds in trust for charitable purposes in Washington as well as here in Toledo. His charitable gifts in Toledo led to the establishment of a fund dedicated to Jewish law, a fund supporting the needs of Congregation B'nai Israel, a communal needs fund, and one to the former David Stone Hebrew Academy. This evening, we welcome Raymond Dowd, a partner in the law firm of Dunnington, Bartholow and Miller, LLP, in New York City. Mr. Dowd serves on the Board of Governors of the National Arts Club and the Board of Directors of the Federal Bar Association, having served as General Counsel in 2011 to 2012. In fact, Glenn McMurray, who is one of his colleagues, is also on the Board of Directors of the Federal Bar Association, and he drove here tonight from Dayton to join Mr. Dowd and to listen to the lecture. So, welcome. Thank you for coming. Mr. Dowd frequently lectures on legal and ethical issues relating to Nazi art looting, including the 2009 Prague Conference on Holocaust-era assets. He has presented at the Jewish Museum in Berlin, Yad Vashem in Jerusalem, the Pennsylvania Academy of Fine Arts, the San Francisco War Memorial, the Sorbonne in Paris, and many chapters of the Federal Bar Association. As a litigator, he has tried fascinating and high-profile cases. I was intrigued by his representation of a trust established by the late tobacco heiress Doris Duke. See, you told me about this last night. Now, Mr. Dowd was successful in upholding the trust, the first honorary pet trust challenged in New York history, thereby obtaining a $100,000 judgment for Ms. Duke's dogs. About 10 years ago, Mr. Dowd represented the heirs of Fritz Grunbaum, an art collector who perished in 1941 in Dachau. Grunbaum's art was stolen by the Nazis following his arrest. Lengthy litigation ensued between Mr. Dowd's clients and the American art collector, who claimed to be a good faith purchaser of a piece of Mr. Grunbaum's art. This case provided Mr. Dowd with his entree into the world of art law. Please extend a warm welcome to Raymond Dowd.
Good evening. Tonight's question, who should profit from the Holocaust? It's kind of a trick question. And the thought is that the David Stone lecture should challenge us to think about an ethical question that might not ordinarily enter into our thinking. And if we think about what flowed from the Holocaust and its profits and proceeds, it leads to a lot of other ethical questions. And when we look at the situation now with ISIS, looting, taking objects out of the desert and selling them through Geneva and them coming onto world commerce, it seems that this question takes on a renewed urgency. So I'd like to take you back, first of all, show you that it's happening today. A lot of these questions are facing our courts and facing the media, and then take you back through time and talk about how this happened, and then challenge you to think about what our museums are and what they should be doing about issues like these. So here we have a slide showing a street scene by Pissarro. And the New York Times reports that a judge rejects a claim for a Pissarro by heirs in a Nazi art case. Headlines like this are typical. We see them all the time. And people come up to me and they're like, I think I saw your case. And I said, well, there's dozens, if not hundreds of these cases, but people in our crowded media world all seem to think that there was that one case involving one Jewish person who had one piece of art, and I must represent all of them. But there's a lot more if we look into the details. So here is another headline. February 24th, 2015, U.S. court asked to act against Germany in a Nazi art acquisition now valued at $250 million. This is a case in the U.S. District Court in Washington challenging Germany's acquisition of a very large treasure known as the Guelph treasure, mostly Christian artifacts. Here we see in 2014 that the Oklahoma State Legislature passes a resolution demanding that the Oklahoma University Museum return Nazi looted art. Oklahoma is one of the most Republican, conservative states in the nation, and this is how its legislators are spending its time. That's pretty shocking to many of us who think, gee, wasn't this all solved many years ago? On Twitter, we see return the Pissarro. So social media is now getting involved with these Holocaust issues. And we see, again, these Pissarro claims are transferred from New York to Oklahoma, and that's just one case. I've given you a slide, and my slides are all available in electronic form from the organizers. Here is a report by the World Jewish Restitution Organization giving a country-by-country review of who's doing the right thing with giving back artworks that were stolen during World War II. And United States is not in the group of countries that are doing the right thing. We have not set up a commission to assist claimants as Britain has, as the Netherlands have, as Germany has, as Austria has, and other countries. So to understand why it is, I think, we should be giving this property back after so many years, we have to start with the American idea of private property. And the modern idea was really articulated by President Abraham Lincoln. And it came about that he hired a gentleman named Franz Lieber, who taught at Columbia, in New York City, who was a former Prussian military officer. And Lincoln tasked Lieber with writing down what the law of war ought to be. And this was in the context of the U.S. Civil War. And Lieber wrote it down, and it became Executive Order number 100, known as the Lieber Code. And indeed, it was in effect until the 20th century. And the Lieber Code, for the first time, set down in writing that the cultural property of the enemy and private property of the enemy should be respected. That is, private property of its citizens and also its cultural institutions, museums, musical instruments, educational institutions, hospitals. These were no longer targets of war. Its cultural goods and art were no longer to be the spoils of war. So in enacting the Lieber Code, the United States adopted a law that rejected the spoils of war doctrine. And in 1899 and again in 1907, the world community, many countries, signed on to the Lieber Code in the form of the Hague Convention. And these Hague Conventions, based on the Lieber Code, that was the law, the international law that was in place during World War I and World War II. So there were rules of the game during the wars of the 20th century that were not in place when the Greeks were around and the Romans were around and all of these other wars that people think about when they think about looted cultural property. The 20th century was different, and the rule of law was one of the reasons why. Now, the Monuments Men, many of you have either read the book or seen the film, and it tells the story of American soldiers going out there, identifying cultural objects and helping troops invading Europe to not bomb churches and museums and monuments of significant cultural worth. And if you read the book or watch the movie, you kind of get the idea that the Americans went in, saved everything, and the story was over. But if you watch Woman in Gold that came out this year, you kind of get the sense that not everything was resolved by these great American heroes. It's the story of, and the actress Helen Mirren portrays Maria Altman, who is a Jewish woman in Los Angeles who sued the government of Austria, brought it successfully up to the Supreme Court, and eventually obtained the return of this artwork, Woman in Gold, portrait of Adele Bloch-Bauer by the artist Gustav Klimt. And if you ever come to my hometown of New York City, you can see this magnificent artwork at a museum called the Neue Galerie that's on the corner of 86th Street and Fifth Avenue. Now, a case that I was involved in, we have Woman in Gold, which was, the case of a woman obtaining the return of an artwork from Austria. But here's a case that I was involved in. I represented the Pergamon Museum, which was located in the former East Berlin. And in that case, I represented really the German government in recovering this artifact. It was a golden tablet that was excavated from the Temple of Ishtar that dated from 1200 BC. It was from the reign of the Emperor Tukulti-Ninurta II. And what happened was, in 2008, it showed up in the safe deposit box of a Jewish man in Nassau County, New York. And the surrogate judge said, well, you Germans, you're too late. Finders keepers, essentially. And how I got involved in the case was I was representing many Jewish families, and if that became the rule of law in New York, all my Jewish clients would lose. So I called the lawyers who had been unsuccessful, and I said, "What the heck? Did you guys argue this? Did you argue that? Did you argue the other?" And they said, "Can you come over and talk to us?" And that's how I got that client. And so we successfully appealed, and we appealed at the mid level, which is the appellate division, and then we appealed at New York's highest court, and we were successful in getting that decision overturned. And on my way up, I was helped by many Jewish restitution organizations because they understood that the rule of law, that once it's yours, no thief can ever take title from you. That was a very important bedrock principle that if we lost it, the Jewish community would never be able to reclaim its property. So the United States is unique in the world for embracing, well, unique. We have Britain, we have the common law countries that also have this rule of law. But the United States has a particular brand of it that's, that makes it more viable for these claims to be brought here. So in a civil law country, you're given, there's opportunities to lose your property rights just by the passage of time. But as we learned in the first year of law school, property class, once there's a thief in the chain of title, no one afterwards can take good title. So anyway, the gentleman came from the Berlin Museum with his white gloves in the courtroom. He inspected with the magnifying glass. He took the box. We put him on a jet, and he flew back to Berlin with this, and that will be displayed at the Pergamon Museum in a couple of years. How I got involved in this area of law was this drawing. This headless woman entered my life in 2005. She is it's a drawing by the artist Egon Schiele. Egon Schiele died at age 28. He left behind him about 3,000 works. He died in 1918, and that was the end of World War I, of Spanish influenza. And Spanish influenza killed more people than the war did. He died within weeks of his pregnant wife dying also of the same disease. And he's considered a great master of 20th century art. His images are very powerful, and museums like the Neue Gallery and others are very proud. Austria, if you know three artists from Austria, you know Klimt, Schiele, and Kokoschka. So Austria is very proud of those three artists of the 20th century. So this woman entered my life by a client walking in and saying, "I got sued over this." And he was a Jewish guy who got sued by another Jewish guy over an Austrian attorney writing a letter to Sotheby's in London and stopping an auction. So my background is Irish Catholic. I'm from New York City. I don't speak German. And I got hired because I knew something about federal civil procedure. And I thought, well, you know, how hard of a case can this be? I read the complaint, and remember, back to law school, if there's a thief in the chain of title, no one can take good title. So here's paragraph 5 of the complaint. The drawing has an established and documented provenance. It originally belonged to the collection of Fritz Grunbaum, a well-known Viennese cabaret performer. In 1938, the Nazis confiscated Grunbaum's residence and inventoried the contents of his art collection. Grunbaum was deported to Dachau, where he died in 1941. Well, there's all the facts I need, and it's in a complaint filed against my client. So I learned that these cases are not so simple. And I want to show you, this is when you look at an auction catalog, we see on the slide a provenance. So we see it started with Fritz Grunbaum, and he had it until 1941, and then it went to his wife, then it went to his wife's sister, then it ended up in Switzerland, then it went to New York, and this is what Sotheby's had published in its London catalog. Except if you knew a little bit about family history, you could see that that was largely fiction, because we know that Fritz Grunbaum died in Dachau. People who died in Dachau were what? Despoiled of everything. Why? Because anyone who died in Dachau had everything taken from them by the Nazis. Elizabeth, his wife, died in a death camp. So nobody could have inherited anything under workings of Austrian law. So the sister-in-law could not have inherited without there being a record, because in Vienna, if you go today, you can find from the 1800s every single probate file that lists every single heir and whatever passed by power of Austrian law. And Mathilde Lukács was not in that list. So somehow it ended up in Bern. Bern is in Switzerland. That's what we call a red flag in a provenance. So this was part of the case that had come to me, and these were some of the issues that we had to go through. So the complaint that I was faced with, one of the issues raised is replevin. That's how do you get something back? That's a chattel, a unique chattel. It would be a painting. Replevin is the legal remedy. Conversion, when you ask for something back that's a chattel and it can't be returned, you can get money instead. So that's a claim for conversion. That was one of the things that we had to deal with. And also the defense of laches. Laches is a common law doctrine. That is, if you sit on your rights and don't do things to protect your rights, you can lose them under certain circumstances. And in New York, the burden of proof is if a property owner can show an arguable claim to good title, the burden shifts to the possessor of the property to show that it was acquired lawfully. So in this case, we said, well, it's the plaintiff who has the work who has to show where he got it from. And these cases, it's very important who bears the burden of proof, because that often determines the outcome. So back to a little bit about Fritz Grunbaum in this period in history. He was born in April 1880 in Brno, Moravia, which is part of the modern-day Czech Republic. As I said, he died in the Dachau concentration camp. He was a cabaret performer. He wrote Broadway shows that were performed on the London stages and in Broadway. He was a film star. He was a radio star. He was, they still laugh at his jokes today in Austria, kind of like an Abbott and Costello type of figure. So he was very famous, and he was famously Jewish, which became dangerous at a certain period of time. And here's Fritz with his wife Lily. And I said, as I said, Lily was deported to a death camp in 1942. So here's a little bit, if you're ever going to work on one of these cases, you have to trace the title, trace the family history. And in this case, my clients, the heirs, had a certificate of heirship from the Austrian government. And my two clients were each co-heirs, one from the Lily's side of the family and one's from Fritz's side of the family, because that, under Austrian law, is how it broke down. I'm going to switch to another case before we come back to Fritz's story, because this is another case that I got involved with that informs my thinking on Nazi looted art. I represented the heirs of George Grosz. Now, George Grosz was pretty much despised by everyone in power that ever ran into him. He was a communist who was a founder of the Berlin Dada movement. And part of the way he managed to bother everyone in a position of authority was to be an anti-militarist. So here's one of his works where a doctor during World War I is certifying a skeleton as fit for active duty. Uh, he was tried for defamation of the Prussian military for these images. He actually sat for trial as an artist. Part of his trial was also this: blood is the best sauce, where we have two generals sitting down, enjoying fat generals enjoying a meal, where soldiers are dying and their blood is producing the sauce. He did not endear himself to the organized religion. Images like these, Christ with a gas mask. The image says, the caption is, "Shut up and do your duty." He was tried for blasphemy. Quakers testified at his trial, and he narrowly, again, escaped imprisonment. So if you think of the artistic traditions of a Goya opposed to the Inquisition, Grosz was an artist who criticized authority at a time when that was to risk your life. And he was a very brave man. One of his targets was Adolf Hitler. And so when Adolf Hitler came to power, the Nazis decided that Grosz was cultural enemy number one. They tried to get him. He fled just before Hitler came to power, and Grosz went on to teach at the Art Students League in New York. But Grosz made a bit of a strategic error. He left all of his artworks in 1933 behind with his Jewish art dealer, Alfred Fleshtime. Fleshtime was a huge figure. He was the premier art dealer in the Weimar Republic. He was very prominently Jewish, and he was famous for making jokes about his nose. Here we have a Rudolph Belling statue of Alfred Flechtheim and his famous proboscis. Here, the Nazi Völkischer Beobachter uses an image of Flechtheim's nose to symbolize the international Jewish Bolshevist conspiracy to poison the German people. And again, an image of Alfred Flechtheim in 1937 as part of the Degenerate Art exhibit, where Flechtheim is perceived as a central figure. So Grosz had left his entire body of artwork with this Jewish art dealer in 1933. And shortly thereafter, the Nazis took everything from Alfred Flechtheim. And we'll get back to a little bit about how that story played out. So how do we know that the Nazis were really bad people? Let's go back to 1920 and look at their party platform, what they told the world that they would do. They said only nationals can be citizens of the state. Only persons of German blood can be nationals, regardless of religious affiliation. No Jew can therefore be a German national. This is in 1920. At the same time, they demanded laws against trends in art and literature which have a destructive effect on our national life. So they were very interested in culture and propaganda and anti-Semitism in a very formal, official, written way very early on. That's 13 years before Hitler came to power. So how is it that Jews lost power under Hitler? Well, Jews weren't the only ones. In March of 1933, Hitler took power from the Reichstag. They burned the Reichstag. He governed by decree under the Führerprinzip. Nazis became the only party by about July of 1933. And in the Nazi party platform and in practice, on about April 1st, 1933, a massive boycott of Jews went on. It was a crime to buy or sell from a Jew, and it was you were a traitor to the German people. So there were massive and persistent boycotts. Jews were denied food and medicine. The front cover of the New York Times reported to be a Jew is a crime in Nazi Germany. This is right in 1933. So at this time, your neighbor took over your property in something called Aryanization. And some of it was superficially friendly, some of it was violent and ugly. But this system of neighbor taking over neighbor's property really didn't benefit the Nazi Party. It benefited individual Nazis. So later on, the Nazis had to invent a more formal system. So initially, Hitler was in power in Germany. He invades Austria in 1938, and the Austrians pretty much welcome him with open arms. At this point, this is when Grunbaum was in the first transport to Dachau. He was arrested in March of 1938, and here's how things were taken from Jews. A lot of our imagery during this period is there were machine guns and people marching and violence directly, but that's not how Jews lost their property. It started with that boycott. And in 1931, even pre-Hitler, there was a confiscatory tax on those who left the Reich. So if you wanted to go to Lancaster, Pennsylvania, and you were German, you put all of your assets into, you gave your assets to the German tax authority. They took 25% and gave you the rest, and you came to the United States. This was whether or not you were Jewish. As soon as the Nazis came to power, they used that mechanism for anti-Semitic purposes and for bigger confiscatory purposes. So they had a Jewish exchange rate that went up to 96% confiscatory. Or when they paid Jews, they did it into blocked bank accounts that the Jews couldn't access. Or they paid them in fake marks called Sperrmarks. So there were sham transactions to despoil Jews who were leaving the Reich. But all of this happened without violence. It was filing papers, it was moving things along, everybody pretended, the birds were singing, it was a sunny day. There was no violence involved on an individual basis for most of these. During the time, it evolved that they passed laws that permitted judges to issue confiscation orders. So a confiscation order says basically, I have determined that this is a Jew, this is a list of the Jew's property, and I order that this identified property be seized and sold and the proceeds to go back to the Reich. So as opposed to an Aryanization, that's a confiscation. And so there's various ways, and there's also another way that people lost were just duress sales from the pressures of the boycott, the fear of what the Nazis would do to you or your family. You fled and you sold things to get money to leave. So you sold things under duress. So each of those has a different legal weight and is considered differently by lawyers and scholars, and there's different differences of opinion. But during this time, when the New York Times is reporting on the front page the plight of the Jews in Germany, tens of thousands of artworks left Germany, left Austria, came directly to the US or through Switzerland or through the Netherlands, and were snapped up by US museums and collectors. Now, the mechanics of how things were taken from the Jews really speeded up in April of 1938. There was a law passed that required all Jews to declare all of their property, all Jews who had in excess of 5,000 Reichsmarks worth of property. So they had to declare commercial property, real property, and other property, and an art collection would be declared as other property. So this is the cover page of a Jewish property declaration that Fritz's wife, Lily, signed pursuant to a power of attorney that Fritz executed while he was in Dachau. So he's in Dachau, signs the power of attorney, permits her to liquidate his property so that it can be paid to the Reich. So attached to the Jewish Property Declaration, we have this inventory. And in the inventory, there's 5 Sheilas that are listed by name. This is the art collection. They're oils. And then there's 76 drawings by Sheila. And again, these are all today very valuable artworks. And there's tons of artworks in here. There's 449 artworks listed. Some of them Rembrandt, Kollwitz, Picasso, and we just don't know which ones they are. That hasn't been sorted out. Sheila's are the ones that we've been able to track. So we took, during the trial, we took all of the Jewish property declarations from 1938 to 1942, and you can see how the Nazis despoiled the 2 Grunbaums of their works by comparing the property declarations until they were 0. And what the Nazis did, and this was a system invented by Adolf Eichmann, who came to Vienna in August of 1938, was to figure out how to make the spoliation of Jews profitable for the Reich. So if you sent a Jew to a concentration camp without liquidating their life insurance policy, that was a loss to the Reich. So this was very orchestrated in a way to completely despoil every Jew before they were murdered. And Franz Kieslinger, who prepared the list of the art inventory that we found in the probate files, became the assistant to Cajetan Mühlmann, who was described as arguably the single most prodigious art plunderer in the history of human civilization, and probably a name you've never heard. Another document that we came up with as we traced Grunbaum's collection, there was an inventory that sort of matches the Kieslinger inventory. That was an export application, because if you wanted to export works that were over 20 years old from Austria, you had to fill out paperwork and then get an export license. So here we can see the swastikas on an export license that were granted in September 1938. But we can tell, because we had an expert in analyzing customs stamps, that even though the export license was granted, the collection never left Vienna, because as a train left Vienna, the customs inspector stamped separate pages. And we could see from the records they have there today that those pages are blank. So that tells us that the collection never left Vienna prior to the end of the Nazi regime in 1945. Now, to think about what happened with all this Jewish property. Remember, the Hitler wants to, a few things happen. First of all of the money that was tallied up in those Jewish property declarations, under the law actually said, is now available to the Reich, to Reichsmarshal Hermann Göring, to implement the 4-year plan. What that meant was the Nazis started pledging Jewish property to banks to borrow for their financing of armaments. Additionally, they had the problem of turning Jewish property into cash. So what do you do with all this household goods and things that you've stolen? How do you turn it into money? For fine art, in Vienna, they sold it through the Dorotheum, which today is Vienna's finest auction house, and it's considered on a par with Sotheby's or Christie's. And here's one of their auction catalogs with a swastika on it. Today, it's very well respected, and it's been privatized. And the lesser works were sold through an organization called the Vugesta. The Vugesta was a consortium of storage companies. And so what happened was Jews were disappearing and storage companies were not getting paid the fees for their boxes. So they complained to the Gestapo, and the Gestapo agreed, you can hold auctions and give the proceeds to pay off the bills and pay the Reich. So they had basically a system of big yard sales. So Jewish property would be sold off on the cheap at these big yard sales, which made the population very happy, and it raised money for the Nazi war effort. There's a notice from in 1938 Berlin sale that I came across, and I got this from the largest collector of auction catalogs in the world, and he said he'd never seen a notice like this, and it was stuck into a 1938 Berlin auction sale, and it's in the English language, and I'll read it to you. Important notice to foreigners desirous of buying at the sale. According to a special permit granted by the competent German authorities, it is possible to have auction accounts for objects bought at a public auction in Germany for an English or American purchaser settled through the Fides Treuhand of Switzerland, and you will get a 30% discount. So, 1938, we know that Jews are being despoiled. English language notice. If you're American or British and you come here and you buy this through Switzerland, we'll give you a 30% break. So what was happening was Americans and British were going over and buying up artwork and settling it through Switzerland. Do we know who, what, how many? No. The Fides Treuhand is a subsidiary of Credit Suisse. No one's ever sued them. No one's ever subjected them to subpoena power. So we don't know the answer to this. Switzerland said they'd investigate it in the wake of all the Nazi gold scandals, but they were given subpoena power and they never even asked these questions. So we don't know today how much passed through Switzerland. And I've given in the materials a website and some reports where you can track down this on your own. Now, how much did the Nazis think they got from these Jewish property declarations? Well, there was a secret finance decree calculation. And what they did was they added up the property of what they called the stateless Jews, and then they talked about how they would liquidate this property in an orderly fashion. Now remember, these people are still alive. These are people who think they own this property, and the Nazis have already figured out how this property is going to be sold in November of 1938. So when you hear discussions about the final solution, most of us think of 1942. Oh, that's when the final solution came about. I look at this, and if we think about motives for the Holocaust, many of us think, oh, yeah, anti-Semitism. Well, here's a financial motive. And this is a very powerful motive that many of us can really understand. Anti-Semitism alone really never sort of persuaded a lot of people about the Holocaust. When you look at the financial motive, it's just extraordinary, and it's there. And this is something that in going through and learning this and discovering this information and talking to historians, learned there's very little literature about the property aspect of the Holocaust, because most of the literature has focused on the murders. So the greatest murders in history have hidden the greatest property crime. And I wanted to show you, this is a power of attorney that Fritz Grunbaum executed in Dachau, and it's got official stamps. He's a Vienna resident in Dachau, and they have him legally sign away his rights. So this happened all under law. The U.S. Consul General remarked, there's a curious respect for legal formalities. The signature of the person despoiled is always obtained even if the person in question has to be sent to Dachau in order to break down his resistance. So Judge Edward Corman, in the case, the headless woman case, it was Bacalar versus Vavra, here's what he wrote. Grunbaum was arrested while attempting to flee from the Nazis. After his arrest, he never again had physical possession of any of his artwork, including the drawing. The power of attorney, which he was forced to execute while in the Dachau concentration camp, divested him of his legal control over the drawing. Such an involuntary divestiture of possession and legal control rendered any subsequent transfer void. This is the American rule. Once there's a thief in the chain of title, no one afterwards can take good title. I wanted to show you from the file, as we think about, well, who was it that was taking all this property? It was lawyers, it was bankers, it was bureaucrats. Here's a letter from an attorney, and he says, "Dear Mrs. Grunbaum, the Department of Foreign Exchange appointed me to deal with the whole property of the Grunbaums." So this would be like a guardian of the property, an Aryan trustee. So Jews were taken over their property. They had sort of a guardianship. And the Aryan trustees would liquidate the property of the individual Jews. And Eichmann pointed out that this was a way that he could get the lawyers to be on his side because lawyers would make a fee. And that would motivate people to assist his effort. And this letter, he says, "You asked me what you owe me and Dr. So-and-so, and it's a bill for 6,500 Reichsmarks." Well, 600,500 Reichsmarks was about double or triple the median salary for a German worker at the time, annual salary. So that's a pretty good legal fee, and really shows a motivation as to why a lawyer would be very much interested in despoiling his Jewish neighbors. And I cite here the Nazi Aryan trustee law that empowered lawyers to do that. And as Getz Ali notes in his book, Hitler's Beneficiaries during this period, at least 9% of the Nazi total government budget was stolen from Jews. That's a significant amount. It's still our public policy in the United States that this property should go back to the people from whom it was stolen. The Holocaust Victims Redress Act of 1998, Congress reaffirmed that, and I cite the language in the materials. But I want to go back and talk about why it is that we ended up with so much stolen property in our museums. And we really have to take a hard look at American museums and our cultural tradition to understand why. So let's start with the great robber baron, J.P. Morgan. Morgan had a huge collection of European art that was fabulous, and he said, "I'm not bringing it back from Europe for American museums if you're going to make me pay taxes on it." So Congress and pliant Senator Aldrich was part of passing the Payne-Aldrich Tariff Act of 1909. And that act added imports of original artworks from Europe that were more than 20 years old to the duty-free list. So that paved the way for the creation of some of our greatest museums. The other thing that is a primary motivator in building museums and the prominence of American museums, because we treat our museums in America better than any other country does for tax purposes and cultural purposes. Andrew Mellon got a big tax bill from the Roosevelt administration back when the income tax was a rather new and controversial thing. And Mr. Mellon said, no, Mr. Roosevelt, I don't owe you any money. I gave these very valuable artworks to the National Gallery, and I should be able to deduct the fair market value of those artworks. And there was a big squabble over it, and Mr. Mellon won. And Mr. Mellon's victory is enshrined in today's tax code that says you get a fair market value deduction for a work of art, regardless of what you paid for it. Now, the significance over most of the 20th century is that if you're wealthy, you could avoid capital gains tax by donating to a museum and thus shelter almost all of your income from taxation by making donations of appreciated works to museums. The translation is that if you're really rich, you've got to find ways of sheltering your income from, at times, it was a confiscatory tax regime in the United States, particularly after the Roosevelt administration. So people scrambled, and they figured out if you're really, really rich, you probably need your own museum. So that accounted for the proliferation of museums in the United States. And today we have really what are considered the world's greatest museums, the greatest collections of European and other artworks. And that's an ethical and social choice. You know, when we think about tax fairness, people who give to museums are not giving to others in our community. They're not paying for schools or housing or roads or most of the things that other people in the middle class are paying for. This is a social choice that we make in our tax code. So the ethical question comes up is, well, okay, that's fine if people are donating legally acquired art, but it becomes much more problematic when they're donating stolen art, and none of us are really scrutinizing those donations, particularly when we see that today in America, there are more museums than there are Starbucks and McDonald's combined. And we go back to saying why. People want tax breaks. So there's articles in the New York Times about some guy has a museum in his backyard, in his barn, that the public can see every third year for 15 minutes. Every time there's a tax loophole, somebody will try to drive a truck through it. That's just human nature, that every time there's something out there, we're going to have a group that abuses it if we're all not vigilant. So the Monuments Men, if you watched it or read it, you thought, well, these are these great heroes. And to a lot of extents they were. But they came back from Europe, having seen all these wonderful treasures. And they looked at their podunk towns and they said, we have these lousy collections. And they all started competing with each other. And they got the wealthy people in their community and they say, we are going to be better than Pittsburgh. We are going to be better than Boston. We're going to be better than. And they went out and they found the best artworks they could, and they stuffed them all into their museums. And that's what we have. Now, during that time, the whole time, the U.S. government, the State Department, is issuing warnings to museums, saying, don't acquire stuff that came from Europe that you don't know where it's from. So here's an example of January 9, 1943, the London Declaration. We all vow we will undo these acts of Nazi spoliation. We know that the Nazis are engaging in these sham transactions. Don't acquire this through Switzerland. We know what these neutral countries are doing to launder these transactions, and we're going to undo it. That's why we fought World War II, was to return all of this. That's why the soldiers died. This is what they were fighting for. But 1964, front page of the New York Times, Europe is still hunting for its stolen art. Can't find it. Gee, I wonder where it is. Hundreds of millions in treasures elude the post-war search. Yet, as this article reports, between 1945 and 1962, 3,978 stolen art objects were recovered in this country by the State Department with the assistance of other government agencies and returned to 14 nations overseas. That's a lot of door knocking in middle America to recover stolen artworks. Messages went out, bulletins from the Department of State to universities, museums, libraries, art dealers, booksellers. They asked everybody, please, this is our duty to the world community to return these stolen artworks. If you know anything, please tell us. And these missives went to the most educated and trusted people in our communities, asking for their help. During this whole time, after World War II, there was the National Stolen Property Act in place. So it was always a crime to receive stolen property, both a federal crime and a state crime. But this was it was law that was never really enforced. And we see today, this is a headline from a newspaper in Tallahassee. Painting set to return to rightful heirs. There's an image of Christ carrying the cross from 1542 that the Department of Justice seizes on behalf of a Jewish family to return that artwork to them. So let's look at the current problem today. Philadelphia Museum of Art, like many major art museums, agreed during the Washington Conference to show works in its collection that entered the country after 1932, but were created prior to 1946 and had been in Europe, because this would enable Jewish families and provenance researchers to identify objects that potentially could be returned to families. So if you go to most of these websites, if you look for provenance or collections, you'll find lists. And here's an example from the Metropolitan Museum of Art. We see that they have 769 records. They stopped, and they don't put in sculptures or graphic works, so their efforts are incomplete. All museums stopped doing that together. But we see a couple of Christ presented to the people, nude by Modigliani, and it'll give some information on that artwork. Here we have a provenance. It's, a bunch of question marks, probably this, probably that. You don't get much more information on that. So these images are still very difficult for families to trace. Gift of Mrs. So-and-so. How does that help you trace where the artwork came from? Art at the DIA. Here's the DIA provenance section. They're touting now. They're going to look and try to establish continuous ownership records. We talk about Nazi looted art, so you can find that information there. And the punchline on this site, we see, it has subsequently been estimated that approximately 20% of Nazi-era looted art remained in private hands and continued to circulate on the market, with much of it finding its way into U.S. art museums. So this is not some lawyer from New York coming here and saying our museums are full of stolen stuff. This is the Detroit Institute of the Arts saying precisely that on their website. How big is the issue? Cleveland Museum of Art director Robert Bergman, now deceased, said, we're talking about hundreds of thousands of objects. I believe for the rest of my professional career, this issue will face the world's museums. 2006, James Cuno, head of the Art Institute of Chicago, tells Congress the amount of research to be undertaken on the tens of thousands of works of art that by definition may have Nazi-era provenance problems is significant, requiring large allocations of staff, time, and money, allocations U.S. art museums have made and will make until the job is done. Morgenthau goes, seizes 2 artworks by Egon Schiele at the MoMA, one of them Portrait of Wally, litigated for 12 years. Finally, Austria settles with the heirs. The other work that he seizes is Dead City. Dead City, remember I showed you the Kieslinger inventory of what was stolen from Fritz Grunbaum? Dead City was on that list. So that was one of the works that Morgenthau seized. But for some reason, Morgenthau, well, I know why Morgenthau let it go. He, as a state prosecutor, litigated up to the New York Court of Appeals that said he didn't have the power to seize those works. So the feds came in and they seized Portrait of Wally, but they didn't seize Dead City. And Dead City was then returned to Austria, and it now hangs at the Leopold Museum in Vienna. So Fritz Grunbaum's heirs haven't gotten it back yet. And this is a catalog raisonné of Dead City 3. A catalog raisonné is something you should know about if you do work in this area. It's a scholarly representation of an artist's work or oeuvre, and it gives very important information on the work's provenance. So the upshot of this 1998 seizure by Morgenthau led to a tremendous international scandal. All countries, 46 countries, came to Washington, had a conference, promised that everything would be returned. Museums told Congress, oh, no, you don't need to pass any federal regulations. Every state's law permits stolen property to be given back. So if something's stolen, we don't need any new federal legislation to assist Jewish claimants to give stuff back because every state's law permits that. But what happened? After the Washington Conference, museums started suing Jews. And they started suing them to keep them out of court. And I want to go through some of the case law that's emerged. And some people are shocked at some of the decisions and some of the positions that were taken by museums. Because think about it. Why do museums need to sue Jewish people? Jewish people are not massing with baseball bats trying to rip things out of museums. There's been no reports of that. So if Jewish people are complaining that they own something, why would you need to sue them? Particularly in the wake of the Washington Conference, where it says heirs are encouraged to come forward, everything should be settled, every nation should have dispute resolution mechanisms. But that's not how the museums went. So let's go through some of the litigation. Here's a good case, one that I like. By the way, I'm a little bit opinionated, and I'm only presenting one side of view tonight, so I apologize for not presenting so much the other side, because I have some pretty strong feelings about it. Weinberg versus Bissonnette. There, the First Circuit affirmed the granting of summary judgment. This was to the Max Stern estate, and in that case, it was summary judgment on a duress sale. Remember, I discussed how certain things were sold under duress, and an expert report was put in, and the judge accepted that an artwork was sold under duress and ordered that it be returned to the heiress, and that you can't just use the word laches to block the return of something that is owned. Now, the really bad cases are two actions. One is the Detroit Institute of Arts involving Vincent van Gogh's The Diggers, and the Toledo Museum of Art Street in Tahiti. And the story behind these two lawsuits is my friend David Rowland is a lawyer, and he represents the heirs of Martha Nathan. And he had a conference in New York, settlement discussion, with a representative of these museums. And he said, well, the Washington Conference, we have to discuss, we're going to settle this, we're going to figure out what the truth is. And they said, oh, no. If you don't, your clients don't give up their claims, we're going to sue you. And he said, you can't do that. You just agreed in the Washington Conference. He said, oh, no, yes, we can. So they walked out of the settlement conference. They issued a press release, and shortly thereafter sued on almost the same day in two separate jurisdictions, Detroit in Detroit and Toledo in Toledo, or Northern District of Ohio. And I'd like to describe a little bit about those cases and how they were decided. Ordinarily, when you file a complaint in federal court and somebody else makes a motion to dismiss, the person who makes the pleadings is entitled if there are disputed facts, to fact-finding, and we call it discovery. So discovery is a powerful tool that's unique to our American adversarial system, and it ensures that a jury will be able to find when there's disputed facts, will be able to make those determinations. And that's part of the common law property rights that, that Abraham Lincoln was so fond of protecting. And here, in both cases, on 12b6 motions, the cases were dismissed with prejudice. And I want to just talk a little bit about one case. Toledo Museum of Art versus Ullin, 477 F sub 2nd, and just to read a section from the decision. In December 1938, the three Jewish art dealers purchased the painting from Martha Nathan for 30,000 Swiss francs, approximately $6,900. In a footnote, the judge notes, defendants refused to acknowledge a sale, citing to the lack of evidence as to negotiation, offer and acceptance, bill of sale, or exchange of consideration, or, in the alternative, the unconscionability of the sale price. Whether a sale occurred is immaterial to the current analysis. Even without a prior sale, there is no dispute that the Toledo Museum of Art acquired ownership through an arm's length purchase from established art dealers. Now, what does that mean? That means that the judge is saying, if you bought it from an art dealer, who cares about whether the art dealer got it legally? Now that flips on its head the common law rule of if there's a thief in the chain of title, no one can take good title. So this is what I would call a really bad decision. This is what I think of as sort of the Dred Scott decision in our area of practice. I can't even believe that it's on the books. And I've spoken to people from Toledo, and they're really in shock and a little bit of denial, and many people said they'd never even heard of this. I go around the world giving lectures on how this is the worst case I've ever seen, and folks from Toledo, it's like, oh yeah, we have a lovely Gauguin, and that was settled. I'm like, no, you took it from the Jewish people, and you sued the Jewish people, and that was really bad. I had a confrontation with the director of the Detroit Institute of the Arts, Graham Beale, and I met him in Prague at the Holocaust Era Assets Conference, and there I said in 2009 the same thing. This is the most disgraceful action of a museum that I'm aware of, and Graham Beale got up, and David Rowland was there, he said, I thought he was going to punch you. And he said, the lawyers told me I had to do it, and he was all red-faced. And I said, well, if the lawyers told you to jump off the Brooklyn Bridge, would you do it? And on top of that, well, fix the problem. Give it back. Publish scholarship. Have scholars look into where this work came from and be public about it. Because history, if you go to the historian's website and look up what history is peer-reviewed research. What these museums are telling us about provenance is not peer-reviewed research. It's just propaganda. They've gone out and promised that they would review and subject to scrutiny the provenance of their collections. They simply have not done it. They're acting really in a bad, unethical way. Another example, museums suing Jews. MoMA and Solomon Guggenheim Museum Foundation versus Schupps. Schupps is a descendant of Mendelssohn, Bartholdy Mendelssohn. Moses Mendelssohn was the great Jewish philosopher, German Jewish philosopher. In this case, Pablo Picasso, boy leading a horse. Bill Paley bought it off the back of a truck in Switzerland. It's one of the great works of the 20th century, modern art, and it's at the MoMA. MoMA sues. Who wins? The case settles. Grosz versus Museum of Modern Art, that's my case. How did I manage to lose this one? This is good. Okay, in New York, we have a statute of limitations. It's the demand and refusal rule. The statute of limitations is 3 years from the date of the refusal. And 2 weeks before the 3-year period is up, my clients say, can you sue? So I met them and we sue right away. So we're 2 weeks under the statute of limitations based on its refusal plus 3 years. No. The judge found an implied refusal because the family negotiated with the museum and engaged in a good faith settlement investigation. The judge said, well, you should have known earlier that the museum's board of trustees was going to refuse. Therefore, I'm going to imply a refusal. Now, this is a federal judge interpreting New York state law. They're supposed to follow the law. Instead, there's a new federal rule on implied refusal. Again, I think a very bad decision that shields the question of whether or not the art is stolen from the discovery process. Another bad decision is Elizabeth Taylor has a Van Gogh. She got it from her father. Again, 12b6 motion on a duress sale. Claim is time barred by the statute of limitations. Now, time barring and statute of limitations in many jurisdictions depends on a legal fiction. The reasonable Jew. The reasonable Jew who is all-seeing, all-knowing, and in 1941 should have known that Toledo or Detroit or somewhere else was either holding an auction or had acquired a work, because no, you weren't busy fleeing Nazis or, you knew exactly where all of your family's goods are because Jews are exceptional people. So the reasonable Jew rule that applies in many jurisdictions now, after the Washington Conference, acts to absolutely bar your rights to assert these claims. And again, even better, they invented acquisitive prescription in Louisiana. So just like I said, in those civil law countries, the law is different. So Louisiana, remember, has civil law. So you can keep stolen art if you're in Louisiana, since there was a federal decision in 2010, the Fifth Circuit said that the doctrine of acquisitive prescription will be recognized. Again, these are bad decisions. And in my case, Bachelor versus Vavra, ultimately, the judges decided that my client's forebears, who had fled to Belgium, should have done something to put the purchaser, the 1964 purchaser, on notice. Didn't say what they were supposed to do. So if you're a Catholic and your grandfather was murdered and, someday somebody knocks on your door and says, hey, this was your grandfather's stuff, you can get it back. But if you're Jewish, you should have done something. And that's as best I can read this Bachelor decision. And the doctrine of laches is, ordinarily, it's if you see somebody buying something at an auction and you know that it's yours and you don't do anything and that person relies on your silence, it's unfair for you to be able to later assert your rights. That's the classic formulation of laches. But these cases have expanded it to cut off all rights, saying that someone unknowingly should have done something in a past life, and the situation for people wishing to recover artworks has been rendered since the Washington Conference very grim by this series of federal decisions undermining the common law right of private property. Now, a little bit of a bright note, last November, the headless woman was auctioned, and the next day, this other artwork, Town on the Blue River, was auctioned. Remember, I had lost due to the latches, and Headless Woman sold for below the low estimate. In the other case, the sellers cooperated with the family. We had a restitution ceremony at the Holocaust Museum, and the other work sold for well over double the high estimate. So even though we were unable to find a legal remedy, we were able to find a good faith solution in that case that ended up really making more available for people who had acknowledged the problems in the past and gotten over them. Now, just very quickly, I want to run through some cases that are percolating in our courts and are either about to be decided or roiling our courts. This is the Von Saar versus Norton Simon Museum case. That's out in California and involving these beautiful works by Lucas Cranach. Cassure versus Kingdom of Spain, involving the Thyssen-Bornemisza collection. DeSeppel versus Republic of Hungary. Was favorably decided by the D.C. Circuit. That case is proceeding in the D.C. District Court, involving a stunning Hungarian collection, the DeSeppel collection. Schupps versus State of Bavaria, they lost at the Second Circuit, and I just read the cert petition last week. Hopefully there's going to be an amicus brief, anybody who likes to write amicus briefs. It's very, very important. Justin Tannhauser, it's an unusual case because Bavaria came back and bought in 1964 a work that it knew was stolen and then took it back to Bavaria. So it gets into very interesting jurisdictional facts. And there's a bit of a bibliography. Going back to the thought of the memory of David Stone and raising some of the ethical questions that face us today, I hope that you'll look at our museums and the choices that we're making with our tax policy, and think deeply about those choices. Is it fair when these donations are being made that they're not scrutinized? And is that fair tax policy? And in the end, is it right? Is it just a public good that we see these beautiful objects in our museums and we don't see where they come from? It's like going to a zoo and seeing animals' heads chopped off and stuck on a wall. It's not the same thing. And if we go to a museum and our idea of beauty is to learn about the history of the object and where it came from and its context and the people who owned it, and that to be our cultural learning experience, I think that our next generations would be much better served. Thank you.
I want to thank David for a very enlightening talk. It was probably one of the finest CLEs that I've been had the experience to sit through. Just fascinating, and again, from the city of Toledo, apologies from our art museum, and what? I don't know. Well, we're going to take questions. Come on up, David. Sheldon, first question.
Who wrote the decision?
All judges are great.
We will take some questions if anybody has any other questions. Stunned silence? Sure, I must be some questions.
The 90% figure, does that indicate that the Nazi business model was sort of headed for trouble, that they couldn't keep plundering forever?
I think they exported their business model in terms of going into Poland and going into Czechoslovakia and going into Greece, where they extensively spoliated those populations, literally taking the food away from them, the populations needed. So they imposed an extreme pain on non-Jewish people as well. They exterminated Slavs. It was a very profitable and, it was a good business model as long as it kept up. I mean, they profited very well from the Holocaust.
Thank you for an outstanding presentation, the CLE I've ever been. Can you indicate to us where and how you came upon the documents for your case?
Yeah, well, as in so many of these cases, you have family divisions, political divisions, people that don't talk to each other, organizations that don't talk to you, a lot of fragmentation in the community. So when the Jewish community of Vienna learned that my clients were being sued, I got a stack of documents like that nobody had ever shared before. And a woman who had researched the case, because there was a whole case of mistaken heirs. Another line thought that they were the heirs, and then there was a whole drama. So I got a stack of documents from her. And then there was a probate researcher who was essentially a bounty hunter who had signed up the people who eventually became my clients, and he had a stock of documentation that had not been shared with anybody else. So I was the beneficiary of probably a good decade of other people rummaging through and trying to find it. There was also some scholarly literature that was published in Austria by a woman named Sophie Lilly, who was acting completely independently. And there was also some theater works written about Fritz Grunbaum. And I also interviewed in Berlin a man who was the foremost researcher on cabaret. And he showed me a film about, I still have it, a film on cabaret in concentration camps, which if you watch that without crying, it's so amazing. Watching Mac the Knife being sung as they're marched off to a concentration camp. It's just extraordinary.
In defense of our wonderful museum, it's been my understanding for at least 9 years, since 2006, that the museum had a painting that was determined to have been stolen during the Nazi era, and that the museum decided to return it. And I just wonder if anyone knows that story, or if it might have in fact been the painting that was determined that we could keep.
No, there's the museum has been embroiled in a number of issues. How it gets spun publicly versus the backstory, I can't comment on. But I've dealt with many museums. It's just sort of the thing like, oh, we decided to do the right thing, and then you talk to the lawyers like, oh yeah, 3 years of where they decide to do the right thing. So you never really sure what the story is as long as it is all this behind closed doors stuff. I can unequivocally say that Gauguin Street in Tahiti, the family was sued, it was never returned, there's been no independent scholarship, and this is not the first time I've given this lecture and said this is an absolute, it's not even one of those cases where you say, well, there's two sides. I really don't think there's another side. And I would tell you if I thought, well, they say this, but thank you.
Who will administer the 1,200 art objects located in Munich?
I'm sorry? Oh, would I like to comment on that is the question? Who's going to administer it? Well, the last I heard, and I just got a book called Hitler's Art Thief that's about that Gurlitt drama, so I'm halfway through it. So when I finish it, I'm sure I'll have the exact answer. But I've been following the backs and forths, and what happened was when Gurlitt died, after this scandal came to light, and in his will, he left it to a museum in Switzerland. And the Swiss museum said, we're not going to accept the collection until the Germans reassure us that the collection's not stolen. So the Germans then set up this bureaucracy to research his collection, and I think that's kind of where it stands. And there are people very unhappy with that process and how Germany is behaving.
Is there a reason the England case wasn't appealed?
Yeah, money.
What happened to the paintings that Hitler and Goering took for their own collection?
Oh, that's a good question. Well, as the books portray, Hitler dreamed of having his own museum in Linz. And they keep saying that all the artworks were returned, and we keep hearing new stories. So Austria has this commission, and every year, every month, they're deciding to either give back or not give back works that have been claimed. So I'm not expert enough to know what the status are, and I have colleagues who are much more up to date on that. But there's a thought that, again, a lot of the damage was not undone. There's a woman who, Nancy Yaida, wrote a book about Goering's collection. And I think only recently this year, there was a complete publication of his entire collection. As to what was given back or where, I'm not up to date on that.
Again, I would ask you to thank Ray for this wonderful, wonderful speech.